criminal law, the stakes are incredibly high. We're talking about a person's liberty and sometimes even their life being on the line. Welcome back, law students, to This Explainer. We're picking up right where we left off, serving as page 2 of Module 6 in your Evidence Law 1 course. In page 1, we introduce the two standards of proof and why they exist. Today, we're going to slowly and carefully dissect the absolute highest standard of proof in Ugandan law, beyond reasonable doubt. We'll look at exactly what this standard means, what it absolutely does not mean, and how Ugandan courts have actually applied it in practice. Make sure you have your notebooks ready. I'll be going at a deliberate pace today so you have plenty of time to absorb and jot down every single critical concept.
So here's our agenda for today. We're breaking this down into 4 clear parts. First, we'll define beyond reasonable doubt. Second, we'll look at what reasonable doubt is not. Third, we'll dive into the key case law authorities. And finally, we'll wrap up with a summary and a quick discussion question to test your knowledge.
All right, let's jump straight into Section 1, defining beyond reasonable doubt, and establish exactly what this foundational legal standard actually means for a prosecution team. Grab your pens because you'll want to get this exact definition down. Beyond reasonable doubt is literally the highest standard of proof we have in Ugandan law. The prosecution has to hit this incredibly high bar in every single criminal case before a conviction can happen. But why is it the highest standard? Well, because it requires the court to be, quote, firmly convinced and absolutely sure of the accused's guilt. If a judge is sitting there after hearing all the evidence and they have any lingering rational questions, they have to acquit. The key here is that any doubt has to come directly from the evidence, not from some outside sympathy or general feeling. Now, let's contrast this with civil law to really put it into perspective. On the right, you've got the balance of probabilities. In a civil contract dispute, for example, the court just needs to think one side's story is, say, 51% more likely. It's a simple tipping of the scales. But criminal courts? No way. You can't just think guilt is merely more likely than innocence. The scales have to heavily and decisively drop on the side of guilt. You have to be entirely sure.
That brings us to Section 2, what reasonable doubt is not. To truly understand this standard, we need to clearly define its boundaries.
Make sure to note down these 3 key exclusions because they really show the practical limits of the law. First off, we are not talking about absolute mathematical certainty. We're dealing with human affairs here, right? So the law doesn't demand proof beyond every conceivable science fiction level of doubt. Second, it is not about mere speculation. We aren't looking for wild, far-fetched conspiracy theories. We are looking for actual, rational gaps in the evidence presented. And third, reasonable doubt isn't created just because the accused stood up and flatly denied doing it. The court has to evaluate the entire picture to see if a rational, evidence-based doubt truly exists. Okay, let's move on to Section 3, key case law authorities. Make sure you leave some space in your notes to write these citations down clearly.
First up is Akbar Hussein Godi versus Uganda, Criminal Appeal Number 3 of 2013. Definitely write that one down. In this case, the Supreme Court of Uganda made it crystal clear. Strong suspicion does not equal proof beyond reasonable doubt. Think about what that actually means in a courtroom. A judge might strongly, deeply suspect someone committed the crime, but if the hard evidence doesn't make them firmly convinced, they absolutely must acquit. If a lower court convicts on just a suspicion, they've totally missed the mark, and that conviction is getting tossed out on appeal.
Next, we have Ntambala versus Uganda, Criminal Appeal Number 34 of 2015. Here, the Court of Appeal hammered home this same strict standard, but specifically regarding witness testimony. This is tricky because a witness can sound incredibly convincing. They can tell a highly probable story. But the court ruled that even then, a judge must be completely sure. It's never enough to just say, well, the witness is probably telling the truth. You have to cross that threshold into total certainty. Now, for a real classic, please note down this famous precedent from the English courts. Wilmington versus Director of Public Prosecutions, from the 1935 appeal cases at page 462. This case established what's famously known as the golden thread principle, and this golden thread runs through literally every single Ugandan criminal case, from the opening statements to the final verdict. The rule is simple. The burden of proving guilt beyond reasonable doubt is always on the prosecution, period. The accused never has to prove their innocence. Finally, write down this highly persuasive authority from Lord Denning. This is Miller versus Minister of Pensions, 1947, Volume 2 of the All England Law Reports, page 372. Lord Denning really nailed the explanation here. He said, the standard requires a very high degree of probability, but not certainty beyond the shadow of a doubt.
Basically, if the evidence against someone is so strong that the only possibility of their innocence is something you'd brush off by saying, well, of course it's possible, but not in the least probable, then the case is proved beyond reasonable doubt. That distinction between possible and probable is everything.
Let's bring all of this together now in Section 4, Summary and Discussion Question.
If you only remember a few things from today's explainer, make it these core takeaways. Double-check your notes against this list. 1. The court must be firmly convinced, though not mathematically certain. 2. Any doubt has to be based on reason from the evidence, and, as a constitutional rule, it absolutely must be resolved in favor of the accused. And 3. Keep these 4 key authorities in your back pocket for exams and future practice. Write them down one last time: Wilmington, Akbar Hussein Ghadi, Ntambala, and Miller.
To wrap things up, I'm leaving you with a discussion question to really test your legal reasoning. Imagine a magistrate convicts someone and actually states on the record, I am not 100% certain the accused stole the goods, but I am satisfied it is more likely than not that he did. So based on everything we've just carefully unpacked, is that a correct application of the standard? What specific error did this magistrate make? And critically, how do you think an appellate court would react? Look back at your notes on the balance of probabilities versus reasonable doubt, and maybe check what the Supreme Court said in the Akbar Hussein Ghadi case to build your answer. Take your time with it, good luck with your studies, and remember to always keep that golden thread in mind.